The time is 11:30. Can I welcome you very warmly to session 2 of this virtual day conference. It's a great pleasure now to introduce Nick Hopkins, Professor of Law at Reading University and a Law Commissioner currently serving his second term. As Mark Hill said just before the break, Nick is now going to bring us right up to date with the Law Commission's proposals following their recent consultation. You'll have seen Anne-Marie's message there in the chat. So once again, we'll take questions at the end. Please use the chat for any questions that you wish to raise. So without any further ado, let us give a warm welcome to Nick Hopkins. Thank you.
Thank you very much. I'm hopefully going to share my screen. Thank you. I'm delighted to have the opportunity to talk to you today about the project we are doing on weddings law and to outline the provisional proposals that we have put forward when given the task that, as Rebecca Probert has explained, was not available back in 1949 of looking at a wholesale reform of weddings law. And I'm very delighted that my talk follows Rebecca's excellent explanation of sort of how we got to where we are, not least of all because Rebecca is playing a key role in developing our proposals for reform through working as an expert consultant on our project. So what I want to do is give you an overview of the background to the work we're doing and the provisional proposals we have put forward, particularly as those proposals will relate to religious weddings and within that the specific provisions that would relate to Anglican weddings. If you are not familiar with the Law Commission, we are a body that was set up in 1965 and we were given the task by Parliament of keeping under review all of the law of England and Wales and making recommendations to reform the law to government. We work independently from government, but we are funded only by government. Our relationship with government is now set out in a protocol. So our job is to make recommendations for reform, but of course, whether those recommendations are taken forward is ultimately a matter for government and Parliament, though historically around 2/3 of the reports that we have made have been implemented in whole or in part. Now, our work on weddings law dates back to 2015, but we have not been working on weddings consistently since then. So back in 2015, we were asked by government to prepare a scoping paper, a paper which did not set out any proposals for reform, but which identified the issues that would have to be considered if a wholesale review of weddings law was to take place. Now, the immediate catalyst for that scoping paper was a commitment that government had made during the passage of the Same-Sex Marriage Act to consult on enabling non-religious belief organisations, particularly humanists, to be able to conduct weddings, which of course they cannot currently do in England and Wales, unlike the position in Scotland. Government's consultation identifies strong support for humanist weddings, but also identified the difficulties in attempting to fit those weddings into the current system. And so government asked us to do that scoping paper in order to identify what issues would have to be addressed if there was to be a wholesale reform. Now, we published that paper in December 2015. It's called Getting Married, a Scoping Paper. And government's initial response, which came in 2017, was that it was not going to ask us to move to a full law reform project, as it did not feel that it was the right time to do so, given other priorities for reform. That position changed in the budget in 2018. In the budget speech, government announced that it was going to ask us to take forward a project on weddings law, which we then began in July of 2019, having agreed the terms of reference for that project. We began, as we did with all of our projects, by preparing a consultation paper, which we published in September of last year. Now, that publication was much later than we had anticipated. The reason for that, unsurprisingly, being COVID, and particularly the impact that COVID was having on weddings. It would, to say the least, have been very insensitive to ask people about how weddings law should be reformed at a time when so many couples were having to postpone their own weddings. So we published in September 2020, and then we had a 3-month public consultation, which concluded early in January this year. We are now analysing the responses that we received to that consultation, and in the second half of this year, we will publish our report with our final recommendations to government for reform. Now, for all of the projects we undertake, we agree terms of reference with government, and we then act independently within those terms of reference to provide recommendations for reform. The key task that we've been set in our project on weddings law is to enable couples a greater choice as to their wedding within a simple, fair, and consistent legal structure. And in doing so, our review is guided by 5 principles for reform. Now, the first 4 of these principles were those that we identified in our scoping paper. So in that paper, we suggested that any review of weddings law should be guided by the need to provide the certainty and simplicity that, as Rebecca has shown, is clearly not a characteristic of the current law, fairness and equality, protect the state's interest, so the state's interest in knowing whether a couple are married, and the state's interest in protecting against forced and sham marriages, and respecting individuals' wishes and beliefs. To those 4 principles, a 5th was added, reflecting the statement made in the 2018 budget when government announced that it wanted us to take forward the project. And that 5th principle is to remove unnecessary regulation so as to increase choice and lower the cost of wedding venues for couples who are getting married. So we are undertaking, in essence, a wholesale review of all of the formalities that apply when a couple get married, from the preliminary stage of the couple giving notice through to the ceremony itself and the registration of that ceremony. So we ask in our consultation paper what preliminaries should be required and how those requirements could be streamlined and made more effective. We look at where weddings should be able to take place and how weddings law could facilitate a much greater range of venues than is the case at the moment, including, for example, enabling weddings to take place outside. We agreed with government that we would put forward a scheme that would enable a wider range of people to solemnize weddings if government decided that it wanted those groups to be able to do so. So we are putting forward a scheme that would enable non-religious belief organisations, including humanists, and independent celebrants, so celebrants who are not affiliated to a religious or non-religious belief organisation, to conduct weddings. But government has not asked us to make a recommendation as to whether those groups should be permitted to marry people. We look at the content of the ceremony and whether particular vows or particular prescribed words should be required. And we also look at how marriages should then be registered. And I should add that both in relation to the giving of notice and registration, our work has sort of assumed the separate work that government has undertaken to introduce a schedule system, which comes into force in May of this year. So a system under which a couple will be given authority to marry, and that authority is signed following the wedding or during the wedding, and then the wedding is registered using that authority. So that separate change is one that we have been able to incorporate into our scheme. And we also look at what the consequences of non-compliance with formalities should be. One of the peculiarities of the current law is that while it lists a number of requirements that must be met, it doesn't always say what the consequence is of not actually fulfilling those requirements. There are also some policy assumptions that underpin the work that we are doing. One of those assumptions is that religious groups will be able to continue to marry people. And the definition of religion for these purposes will remain as it was given by the Supreme Court in the Hodkin case back in 2013. There are also a number of issues that are specifically excluded from our review. So the first of these, and picking up on the question that James Berens asked earlier, is the idea of universal civil marriage. We looked at that issue in our scoping paper, and we concluded in the scoping paper that universal civil marriage takes away choice rather than gives choice. And as the terms of reference we have for weddings are to increase the choice couples have, universal civil marriage would run contrary to that. Essentially, what we find under the current system is that some couples can have the wedding that they want legally recognised, while others can't. Rather than sort of taking away that ability from couples who already enjoy it, we want to enable more couples to have that same ability, the ability to have the wedding that is meaningful to you recognised by law as your marriage. Also excluded from our review is that question as to whether non-religious belief organisations and independent celebrants should be able to conduct weddings, as I explained earlier. The ability of religious groups to not solemnise same-sex weddings, in essence, the quadruple lock contained in the current law will simply be transposed over into the recommendations that we make. We are not questioning the duty of the Church of England and Church of Wales to marry parishioners. And we are also not looking at issues of capacity to marry. We're not looking at the prohibited degrees within which parties are not able to get married or the age of marriage. And the question that's in the news periodically as to whether 16 and 17-year-olds should be able to get married with consent. And we're not looking at the rights or responsibilities that a couple have once they have married. So our focus is very much on the legal question of what formalities must a couple follow in order for their wedding to be legally recognised. And in our consultation paper, we put forward provisional proposals for an entirely new scheme of weddings law, so a scheme that would replace the 1949 Act and provide the wholesale reform that that Act was not able to provide. Our reform would replace the current law in a way that we think would make the law simple, fair and certain. A key feature of our current law is that it moves the focus of regulation away from the location in which the wedding takes place. At the moment, in almost all cases, the building in which the wedding takes place. And it uses as the focus of regulation a new legal role called the officiant at the wedding. I will say more about that role later, but it is a newly created role in which all weddings would be attended by an officiant, and regardless of the type of wedding, that officiant would have the same legal responsibilities. And as far as possible, we've sought to ensure that the same rules can apply to all types of weddings. Now, alongside our consultation paper, we published a summary of our provisional proposals for reform. And in those documents, you will find a number of infographics sort of explaining our provisional proposals. I've put one of those up here. Don't worry about attempting to read what will no doubt be sort of small type on a screen. But what it shows is the path to marriage that a couple would have to take under the scheme that we put forward in our consultation paper. As at the moment, that path is divided into 3 distinct stages. The stage where notice of the wedding is given, then the ceremony itself and all the rules that govern that ceremony, and then the final stage of registration. And what I want to do in the rest of my talk is look principally at the first 2 of those stages, the preliminaries and the ceremony, identify some of the problems with the current law that we found during the course of our work, both at the scoping stage and preparing the consultation paper, and explain the key provisional proposals that we've made for reforming the law. So starting then with the preliminaries. Now, as you'll be aware, in almost all cases, with the exception of Anglican weddings, weddings are currently preceded by civil preliminaries. We were made aware of a number of concerns about how the current rules on civil preliminaries work and the restrictions that they contain. So at the moment, couples must live in the registration district in England and Wales for 7 days before they give notice of their intention to marry at the register office within that district. They then have a 28-day waiting period before they can get married. Now, one of the immediate difficulties that gives rise to is that it's very difficult to marry in England and Wales if you are not resident in England and Wales. Now, that may either be because you're a foreign national who wants to come over to England and Wales for your wedding, or it may be that you are a British national resident overseas who wants to celebrate your wedding with family in England and Wales. In order to do that, you would either have to make 2 trips, one of at least 7 days to establish residence and give notice, and then come back after your 28-day waiting period, or you would have to make a single trip and stay in England and Wales for 5 weeks in order to give notice and then to get married. But the rules don't also work against those from overseas who want to get married in England and Wales. There are some very practical difficulties for those living in England and Wales who want to give notice of their wedding. You have to give that notice in the district where you reside. So that means, for example, you can't give notice in the district where you work, if you usually work in a different district to your district of residence. It also means that a couple can't give notice together if they happen to live in different registration districts. Now, once notice has been given, the notice has to be published at the individual register office in what's described as a conspicuous place. The purpose of that is to publicise the wedding and give the opportunity for those who are aware of impediments to that marriage to raise those impediments. But in the discussions we've had, we have never come across a case in which that notice posted in the Register of Office has led to impediments being raised. Where those impediments are raised, it's because they were known about in any event. So we reached the conclusion that not only is the law around civil preliminaries not helping the couples give notice of their wedding, they are also not actually achieving one of the key aims they are intended to achieve of publicising the fact that the wedding is going to take place. So in our consultation paper, we set out provisional proposals to change the operation of civil preliminaries. A key aspect of our proposals is to turn the initial stage into a two-stage process. Now, it may be felt that turning a single stage into two stages, adding complexity rather than taking it away, but these two stages are intended to be facilitative. And the two stages could indeed be fulfilled at one time, at one visit, if that is what a couple wanted to do. So onto the two-stage process, the couple would initially submit notice of their intention to marry. That could be done online, in post, or it could be done in person. Once that notice has been submitted, the 28-day waiting period would begin. The couple would then have to attend the Register Office for the in-person interview, and they would have to do that before the schedule authorising their wedding is issued. And we ask the period before which the issuing of the schedule, that in-person notice should take place, whether it should be 3 days, 7 days, or some other period. Now, the interview could take place at any Register Office, so no longer any residence requirement, giving the flexibility the current law does not allow. Notices of those weddings would then be published online rather than in the registry office. So making use of current technology so that those wedding preliminaries can fulfill the role that they are intending to fulfill of enabling people to find out when a wedding is going to take place. I then turn to Anglican preliminaries. It won't be a surprise to this audience if I say that the rules that govern the giving of bans are complicated and are prone to mistakes being made. It sounds deceptively simple to say that bans are the reading out of a notice of the intended wedding for 3 Sundays during a church service. In practice, that requirement, the details of that requirement, spans some 13 sections of the 1949 Act. And that Act is no longer comprehensive, so it's no longer achieving its role of codification because of changes that have been made to the reading of bans outside of the Act. That, of course, all increases the chances of errors being made. Bans are also no longer effective in doing their job of bringing to light any objections to that marriage by making people aware that the wedding is going to take place. Bans go back to a time where society was much more cohesive and would naturally coalesce around the church. So the reading of bans would tell the local community that the wedding was going to take place. Nor are bans, it seems, doing the job the state needs them to do as robustly as civil preliminaries. So there is no requirement that the priest meets both parties, and nor does the priest have the power to check documents or to ask the couple getting married to provide documents to them. There are differences in treatment as regards non-nationals, as not everyone getting married in an Anglican church can access Anglican preliminaries. You have to be a relevant national in order to do so. And there is also the so-called problem of limping between the Church of England and the Church in Wales. So the Church of England has amended rules relating to preliminaries through measures as it is able to do, but those measures do not apply to the Church in Wales, as only legislation can alter the preliminaries as far as the Church in Wales is concerned. So we end up in a position that even within the Anglican Church, the same rules do not apply as between the Church of England and the Church in Wales. So we put forward a number of fairly modest options to reform Anglican preliminaries in the event that they are retained under a new law. Those options for reform would include removing and abolishing some redundant rules, changing the rules so that bans would only have to be published in one church, and providing what the law doesn't currently provide, which would be a formal requirement that both parties should meet, the priest, and that the priest should be able to require the parties to produce evidence so that they can be made more robust than is the current position. But alongside that, we also asked the question whether, in fact, the separate scheme of Anglican preliminaries should be retained, or if we should move to a system of universal civil preliminaries, so that all couples who are getting married, regardless of the wedding that they will have to go through the same set of preliminaries. Now, we are a law reform body, we are a group of lawyers, and we look at issues inevitably through legal eyes. Through those eyes, it is very difficult to rationalise a position in which parties who are getting married may go through different sets of different sets of preliminaries according to the type of wedding that they are going to have. It's also very difficult to produce a scheme of Anglican preliminaries that both does the job the state wants it to do and serves the purpose that they seem to serve for the church of providing pastoral opportunities. So we ask whether, in fact, Anglican preliminaries should be removed and a scheme of universal civil preliminaries introduced. But we are aware that this question is not simply one that has a legal answer. We are aware that for the church, there are strong views around the role and purpose of these Anglican preliminaries. So moving from the preliminaries to the ceremony itself, and beginning with the question of who is responsible for that ceremony, particularly for the registration of the marriage following the wedding. Now, what we find as a fairly familiar theme under the current law is that there is a lot of inequality here between different groups. So there are different rules for different categories of wedding. So as far as Jewish and Quaker weddings are concerned, there are no rules about who must attend the wedding, only rules about who must register it. For all other religious weddings, a person authorised to register the marriage must attend. While for a civil wedding, 2 people must attend, the superintendent, registrar, and the registrar. there is also a lack of clarity about the responsibility that person has. The most consistent requirement is that this person is required to register the marriage, but some have additional roles. So Anglican clergy alone, for example, are also required to solemnize the marriage. And the rules contain what we feel is an unnecessary layer of regulation. So, for example, the requirement of having both a registrar and superintendent registrar at a civil wedding, we've heard places very practical limits on the availability of civil weddings at busy times of the year. So our proposals for reform are to create a common set of duties and responsibilities that must be performed in relation to a wedding, and to say that these responsibilities in all cases should be performed by the person we describe as an officiant. So the role of officiant would be a new legal role, and the officiant would have three key duties. They would be required to ensure that the parties freely express their consent to marry each other. They would be under a duty to ensure that the other requirements of a ceremony were met, for example, the requirement that there be two witnesses. And they would be under a duty to ensure that the schedule is then signed. Now, onto the proposals that we put forward, there could be up to 5 categories of officiant. Registration officers would continue to perform the role they do now in relation to civil weddings. Anglican clergy would then fall within their own category, and I'll say more about that shortly. Other officiants would be nominated by religious bodies, and if government enables non-religious belief organisations to conduct weddings, then those organisations would also be able to nominate officiants. There is a specific category of maritime officiant to enable weddings to take place on UK registered ships in international waters. And a category of independent officiants, again, if government decided to enable independent celebrants to conduct weddings. So I'll talk more, first of all, about the position of Anglican clergy. So under our scheme, we propose that clerks and holy orders of the Anglican churches would, as is the case at present, be automatically authorised to officiate at weddings by virtue of their ordination. Now, the exact definition of clerk and holy orders would be a matter for the Anglican churches, and all aspects of regulating and training Anglican clergy would remain with the Anglican churches. So essentially, in terms of officiants, there would be no change. We do not see sort of any reason to depart from the particular role that Anglican clergy have, which recognises the duty they have to marry their parishioners. Turning to the second category of nominated officiants, for all other religious bodies, they would be able to nominate those who could officiate at weddings on their behalf. We ask a question in the consultation as to whether this nomination would have to be individually by name, or whether organisations would be able to nominate by role or by office. In order to nominate an officiant, the nominating body would have to meet the description of a religion in Hodkin, have 20 members who meet regularly for worship, and have a wedding service or a sincerely held belief about marriage. Now, that requirement of 20 members reflects the current requirement that has to be met in order for a building to be registered. We did hear during the consultation process some concerns as to whether 20 is a sufficient number once the requirement of a building is removed. And we are looking at how collectively our scheme can ensure that only the appropriate groups are able to nominate officiants. Now, as far as these nominated officiants are concerned, there would be a requirement that they are a fit and proper person who have received training in their duties as an officiant and continuing professional development, but an expectation that those would all be provided by the nominating body. They would be prohibited from making a business of officiating at weddings by elevating the making of profits above the expression of their beliefs. Now, the monitoring or regulation of these officiants would fall primarily to the nominating body, but there would be a residual role for the General Registrar Office where the nominating organisation itself failed to act. We do, of course, have to bear in mind that nominating bodies will take a variety of sizes and structures, from potentially sort of small congregational churches through to much larger and more organised religions. And there would be a public list of the nominated officiants. Oops, apologies. And moving to the ceremony itself. Apologies. There, apology. I'm trying to tackle multiple sources of technology here with my notes and slides, and my left and right hand do not appear to be as coordinated as I would like them to be. So moving to the ceremony itself, and again, what we found with the current law is that different restrictions apply to different groups. So as far as civil ceremonies are concerned and religious ceremonies other than Anglican, Jewish and Quaker, the ceremonies must contain prescribed words. So declarations that the couple are free to marry one another and the words of contract. Anglican, Quaker and Jewish ceremonies don't, however, have to contain those words. The only requirement is that they take place according to the rites of those groups. There are restrictive rules about religious content in civil weddings, essentially that only incidental references are allowed. And we've heard a number of difficulties that gives rise to, not least in its inconsistent interpretation. We've heard, for example, of registrars having objections to the lighting of candles during a civil service, and even to the presence of a stained glass window in the room where the service will take place. It's also clear that that restrictive approach does not meet the wishes of couples. Couples who do not want a religious service themselves may want religious content that reflects their background, their belief, particularly if they're from different faiths, or the beliefs of their families. There is also a requirement, but again, it only applies to some ceremonies, that the wedding takes place with open doors. So this applies to civil weddings and weddings in registered places of worship. So again, religious weddings other than Anglican, Jewish and Quaker. But it's a requirement that does not seem to serve its purpose. We have not heard of cases outside of Hollywood films in which somebody bursts in to the wedding in order to raise a valid objection. So our proposals for reform here are that the same rules should apply to all weddings. The core and indeed the only legal requirement of the ceremony would be that the couple must express their consent to be legally married. But the law would not prescribe how that consent is expressed. It may be by words, it may be by conduct. Now, of course, it would remain possible for religious groups to set their own rules and to say that they would only conduct weddings according to the rites and traditions of their own religion. We also suggest that there should be greater freedom to have religious content in civil weddings. In effect, we suggest reversing the current position, and rather than saying you can only have incidental content, saying that you can have any religious content as long as that ceremony remains identifiable as a civil ceremony. And there would be no requirement for open doors. And then we have the issue of the location in which the wedding takes place. So most religious weddings currently must take place in a place of worship, although again we find different treatment in the existing law, because there is no limitation of venue as far as Jewish and Quaker weddings are concerned. And indeed, Anglican weddings by special license can, in theory, take place anywhere, although we do understand that the Archbishop only issues licenses for weddings in Anglican places of worship, such as private college chapels. But beyond the differences in treatment here, the law simply does not work for some religious groups or couples. There are small religious groups that don't have places of worship that they can register. There are also religious couples who do not wish to marry at the place of worship because their religion does not look to the place of worship as the place to get married. We understand, for example, that that is often the case for Muslim couples because within the Islamic faith, the wedding is not a religious sacrament, but a civil contract. So our provisional proposals are that weddings should be able to take place in any location. That could be inside or indeed outdoors. The only requirement would be that the officiant agrees to where that wedding takes place, and in doing so, the officiant gives consideration to the dignity of the wedding and, of course, to safety. Now, again, it would be possible for religious groups to require their weddings to take place in particular locations. So those religions that would want weddings to continue only inside the place of worship will be able to continue to require that to be the case. In terms of civil ceremonies, there would be an optional system for pre-approval of premises, simply as an efficiency measure so that registrars did not have to check the suitability of a venue on every occasion. Now, I'm going to show another graphic from our consultation paper and summary, which is designed to show the rules that would apply to all weddings based on the different type of officiant who would be required to attend. And that, as it illustrates, with very few exceptions, the same rules would apply to all weddings. And that's a point that I want to reflect on before concluding and handing over to questions. We've had around 1,600 responses to our consultation paper, which is a fantastic number of responses and shows the level of engagement, the level of interest and importance there is around the law relating to weddings. And within those responses, as we would expect, we've heard a diverse range of views on our provisional proposals, from those who are strongly in favour to those who are strongly against, and every shade in between. A common theme that emerges from those responses is a high importance that consultees place on marriage and on weddings, both for themselves, for the groups that they belong to, and for society as a whole. And one of the criticisms that we've received, including from the Anglican Church, is that we have not engaged with the question of what marriage is, and that we are devising a law for weddings without reflecting on the meaning of marriage. Now, to an extent, that criticism is fair, because it reflects the terms of reference and it reflects the task that we have been given to do. We're not looking, as I said before, at issues of capacity to marry or at issues of marrying below the age of 18 with consent. We're not looking at what groups should be able to marry people, and we're not looking at the rights and responsibilities that marriage involves. But we are very aware of the many different meanings that marriage has for different people and a variety of ways in which it's celebrated. That's something that's been apparent to us from the beginning of our work in 2015 and has been made clear to us again as we've prepared our consultation paper. And in that regard, I was struck by a fairly recent decision of the High Court by Mr. Justice Mostyn, a case on capacity to marry, in which he surveyed the case law on the meaning of marriage. And as I think these extracts from his judgment demonstrates, the legal status of marriage is highly flexible. While many marriages will involve some or all of a shared economy, cohabitation, sexual relations, and procreation, none of them are essential to its legal status. And it's with that flexibility in mind that we have devised our scheme, and that we have sought to put forward a scheme that is simple and certain, and that reflects the many different ways in which people choose to celebrate their marriage and the many different legal meanings that marriage has. And that's why, for example, we've provisionally proposed that weddings should be able to take place in any type of location, while recognising that some religious groups will wish to continue conducting weddings only in the buildings in which they worship. It's also why we've proposed that couples should be able to express their consent in any form, while ensuring that organisations will be able to require only their prescribed liturgies to be used. There may be many with strong and sincerely held religious beliefs who would not recognise all of these unions as marriage, but in law they are. Now, of course, religious groups have the right to continue to celebrate and support only those marriages that fit their views of what a marriage should be. We understand that, we respect that, and our provisional proposals enable that. But the law governing weddings has to reflect the diversity of marriages that are formed and celebrated in England and Wales. As I noted at the beginning of my presentation, the terms of reference for our project include the principle of respecting individuals' wishes and beliefs. We think our proposals do that while protecting the state's interest and also protecting the legitimate interest religions have of celebrating only the marriages that they recognise and only in the way and in the venue that they recognise them. So thank you very much both for listening and for your patience in my technical hiccup during that presentation. We are now analysing the consultation responses that we've had and formulating our policy, and we will publish those final recommendations for reform in the second half of this year.
Nick, thank you very much indeed. That was absolutely fascinating. A real tour de force in terms of taking us right through those proposals. As you might have seen from the chat, there's been a lot of comment and quite a few questions, which is great. We've got about 10 minutes. I'm going to go first of all to Matthew Chinnery, who has asked a very early question about the common law duty to marry parishioners being out of scope. And then I'm going to take questions from Howard Connell and Caroline Harris together, who've asked questions about sham marriages and forced marriages, respectively, and I'll scope out some other questions. So, Matthew Chinnery.
First of all, I'd like to thank the Law Commission for all their work and their consultation with us at various stages. It has been very good to work with you. But I'd like to talk a little about the dog that doesn't bark in this consultation. And you noted in your talk that the common law duty for the Church in Wales and the Church of England to marry its parishioners is out of scope. Could you explain why this was, if you know, and has it hindered the Commission's work? And what are your own views about it, notwithstanding the fact that it's out of scope of your official work? It does, to comment on it briefly, it does seem to me that so many of the Commission's proposals are based effectively on a contractual model. The government can regulate by light touch because the churches individually will be able to regulate, or religious organisations will be able to regulate how they undertake marriages. I'm not necessarily sure that's the case for the Church of England, and particularly the Church in Wales, where the Welsh Church Act says that our law only applies to members. So I'm not clear how regulation is going to work for people who are not members of these churches that exercise their rights to marry.
Yep, thank you. I suspect that this is one of those occasions where the answer is in fact shorter than the question. And inevitably on those occasions, that means that the answer is going to be unsatisfactory. For all of our projects, we agree terms of reference with government. And those terms of reference tend to reflect the issues that government does and doesn't want an independent view of. Because we're an independent body and funded by government, there is, I suppose, a general principle of accountability that if government isn't interested in reform of a particular area, or isn't interested in a type of reform, for example, universal civil marriage, then there's no point in us using public resources to provide an independent view on that. So the short answer is that those issues are out of scope because they're not matters on which government is interested in an independent view. Now, because of that, I don't have any personal view on those matters. As law commissioners, our task is not to impose our own view of the world. Our task is to listen, with a degree of detachment to the views of consultees and apply legal analysis to them. So I don't have a view. We have been perfectly happy to provide a scheme that reflects those existing duties without any opportunity to challenge it.
Thank you very much. Okay, so we're now going to move to Howard Connell, who will ask a question about sham marriages, and then I think if we go straight on to a question from Caroline Harris on forced marriages, and then Nick, over to you for both of them. So, Howard Connell.
Can you explain what proposals you're putting in place to prevent sham marriages as part of the registration of the preliminary interview process? I ask because I'm on the Isle of Man, where we have fairly limited resources to make necessary inquiries. Yeah,
I mean, essentially, in relation to the sham marriages, we are relying on the protections that already exist.
Yeah,
and so we're ensuring that the sort of registrar has the information needed, and that the checks that are made at the moment are undertaken. So our approach is essentially being to rely on what is there and ensure that nothing we do upsets that level of protection.
Thank you.
Yes, good afternoon, everyone. Yes, my concern really was relating to the extent of any interview of a couple to be married, and whether, for example, there is an independent interpreter provided if required, whether each half of the couple is interviewed separately with a view to ensuring that this is properly with consent and not otherwise.
Yeah, I mean, certainly that there would be an interview with each of the couple separately. we haven't specifically addressed the issues of interpretation. But it is, of course, kind of essential that both of the couple know what it is that they are doing at the stage of giving preliminaries, and indeed at the ceremony itself. So we don't specifically address the issue of interpretation. I suppose we, because we're putting in place a legal scheme, we have kind of stepped back a bit in terms of kind of operational matters that we would see that as falling within.
Thank you.
Thank you very much. I'm now going to go to Ian Blaney, who's got a question about beliefs about marriage and Article 9, and if that's okay, Ian. And then Neil Patterson asked quite early on an interesting question about bans. So then on to Neil. So Ian, please.
Thank you. As I read the Law Commission's proposals, a non-religious organisation will be able to apply to be authorised to do weddings if they hold a belief about weddings, or they have a form of wedding service that is dignified. The question is really, what beliefs will these non-religious organisations hold about weddings? If I just give a sort of very provocative and frivolous example, if you have, it applies, I think, to independent celebrants as well. If you have people who believe, well, we want to live in the collective and we don't believe that marriage is actually an exclusive partnership between two people, but we ought to have multiple sexual partners. In fact, at our wedding, we want to have our other sexual partners there. And actually, we don't believe in this Judeo-Christian old fuddy-duddy view of marriage. Will that be an acceptable belief which a registrar office will authorise? And isn't there a danger of moving the boundaries of what marriage is indirectly in practice on the ground without the intent of a legislator in Parliament having been articulated at all?
Yeah, I mean, I hope I can reassure on that, because the belief in marriage held by a group would have to be a belief that meets all other aspects of law. So it would have to be a belief that marriage was between a couple. And that the rules preventing bigamous marriages, for example, would remain in place as they are now. And it would have to be a belief in that marriage between those who the law recognises at the moment as having capacity to marry. So that the sincerely held belief would have to reflect those sort of general legal requirements. We have been doing a fair amount of thinking about how you appropriately capture those in a way of ensuring that you don't end up not only with some of the sort of provocative situations you put forward, but also ensuring that you don't unintentionally find that you've enabled groups to marry who, if you kind of stood back and looked at them individually, you would not wish to do so. And so one of the ways of doing that, for example, is looking closely at the interaction with human rights and with the protections provided under the Human Rights Act, which of course the sort of humanists have raised recently in the Harrison case in relation to their own position. So we don't see those requirements as undermining the essential legal features of marriage, that it is a union between two people and it is a union that they are committing to each other for life. The challenge we have is how to capture that within the legislation.
Thank you very much. There's a really, really lively chat going on, so I hope a lot of this will be picked up. This will be picked up later on in the panel discussion. It's coming up to 12:30, or it is 12:30. I did say Neil Patterson could ask a quick question about ecclesiastical preliminaries and bans, and then we'll finish for lunch. Neil.
I think, am I heard? Yes, sorry. Yes, it was a question really responding to the current situation. This is from a rural diocese where calling bans is frequently complicated because churches have services sometimes perhaps once a month, and also where there are frequently couples who have qualified to marry by virtue, or wish to qualify to marry by virtue of regular attendance, and have been unable to regularly attend because there have not been services. And as a surrogate for marriage licenses, I find myself advising people who are in a kind of stuck position, all sorts of ways. I just wonder if you'd like to comment on the way in which that has shown up the historical assumptions behind our preliminaries and the problems they bring us.
Yeah, and I think that echoes some of the concerns that we heard generally about the operation of bans and the complexities they involve. And we know, of course, in the General Synod debate as well, that there are different views about that, as between members of the church as well. In terms of the suggested reforms that we put forward, if Anglican preliminaries are retained, it would simplify the position. It would not necessarily resolve all of the complexities, particularly those you mentioned at the moment in terms of the inability of people to attend services because of COVID. We do separately in our report consider whether there should be provision for emergency sort of measures that could be put in place when there is a national emergency that would resolve some of the difficulties that have arisen under the current law. But not the specific one you raise about the inability of people to get together. I suppose at the moment that would be dealt with through requesting a license as a replacement for the bans, as often happens where something has gone wrong in the calling of the bans.
Thank you very much indeed, Nick. Can I just say thank you all ever so much for the questions. I'm sorry if I didn't get to you, but obviously there will be the opportunity later on to pick this up in the panel discussion. Just before we break, can I just say a huge thank you to Nick. It's absolutely a huge privilege for us to have somebody who is directly involved in drafting these proposals to talk to us today. So Nick, thank you ever so much, and we look forward to hearing from you again at the panel discussion. If we could show our appreciation either with physical or electronic hands, that would be great. Thank you.